Hello, everyone. You are listening to the C Squared podcast with Corey and Curtis. Today, we are back again with a guest we've had before, but haven't had for a while, Mr. Russ Mikow of Rocksteady Law, who is going to be talking to us about some legal things that most bands don't consider. These are things that can end up getting you in a lot of trouble. So, I mean, I know there's that old stereotype of law being boring, but it is extremely important that we go over these things so you guys don't land your band in some hot water down the road. But before we get going, I just want to say thank you for joining us again and braving the chaos that is me and Curtis.
Well, thank you for having me back. I appreciate it. I'm glad they didn't cancel the podcast after my last one.
No, not at all. It's important that we go over these legal things.
Yeah.
So
were you going to say something?
Yeah, before we start, can you kind of go over a background of what we were talking about? Because we're going to be talking about Soundgarden and specifically what happened with Chris Cornell and the legal situation there. So Russ, can you kind of give a breakdown to your understanding?
Yes.
What happened?
Yeah, the Soundgarden case is a pretty interesting intersection of band agreements and things you need to pay attention to as a band, and also from an estate planning side, once you've reached that level that your estate might have residual royalties and other monies coming in from the band even after you've passed away. So in this instance, and I'm drawing a lot of what I'm going to talk about today just from what I've read in the media and other descriptions of the legal controversies between them.
Yeah.
And here's kind of my initial impression. I think this is a problem with the band agreement more than the estate planning side of things. Because once you've reached a certain level, bands have to take into consideration, well, what happens if somebody leaves? Whether voluntarily, they get fired from the band, or they pass away. What happens to their interest? Because in most instances, those agreements act as like a partnership between the individual members. And as a general principle, partnership agreements will have sections and contents of what will happen if somebody leaves. And in this instance, I'm going to assume that just from what I know from the general media and everything is that their band agreement, it allowed Chris Cornell's interest to be transferred, of course, to his heirs through a will. But considering they can't actually do anything at this point without the agreement of Chris Cornell's widow, makes me think that the band agreement quite likely requires unanimous agreement on almost anything band related. Therefore, they need her agreement in order to market things, release new issues, reissues of past albums or new compilations, things like that. So that's, I think, is what the heart of the agreement or the heart of the problem is, that she has basically a veto over anything unless she agrees to it. And that would be a band agreement issue.
Well, hold up one second, Russ, just so I make sure I'm following here, and I apologies if I'm not.
Sure.
So Chris's widow is now considered to basically be a band member legally because she has to approve anything. The whole band has to approve anything unanimously, correct?
Or a partner in the band, which is probably a separate entity itself legally.
Okay, so my follow-up question to that, and again, apologies if this is a dumb question, is kind of like, so is that a normal thing for the widow or a family member to take on this role after the death?
It all depends on what the actual agreement of the band members acting as the band have agreed to in writing and signed. And a lot of bands will fall into well, everybody wants to get along.
Yeah.
if you're in a band. And you want everybody to have an equal say in what happens with the band. And a lot of times, if you're a small group and everything, or starting out, that's fine. But at some level, if you get big, what happens if one member doesn't agree?
Yeah.
Well, then nothing happens. And that's a problem in the general business community itself, not just music band related, because
Yeah.
then you fall into problems like this where nothing happens. And it's perfectly legitimate that Chris Cornell in his will, passed his interest in the band and the partnership into his heirs, his wife. But that also begs the question, in the band agreement, was there a provision allowing the other members to buy out the widow's or heir's interest? If
Yeah.
so, that solves the problem, because then they can make a reasonable offer. If it's rejected, they can go to court and get a court order, and force a sale of the interest through.
Yeah.
It doesn't sound like any of that's going on here. And it sounds like a big boondoggle, because they literally are suing each other to do the most basic things, which is not what a band wants to have as an end result in this type of situation. So a band that's reached a level, or is anticipated to reach a level, of success in the industry, where they have a regular revenue generated, will want to keep two things in mind. One is the band agreement side, and the second is what happens if I die.
So,
because you have to think of both, or
Okay.
else you fall into this situation where you require the complete unanimous agreement of everybody to do anything, as opposed to having majority rule or supermajority rule, where two of the three members or three of the four members can make a decision over the objections of one dissenting member.
So how do you, again, apologies, it is the basic law question because I do not know these things. So how do you kind of set it up then, so that way, if the majority will rule on that without upsetting someone? Is there a way to do that?
You have to agree to it in the initial agreement that's signed by the band.
Fair.
Because you're not chances of you getting somebody to agree after the fact is probably pretty slim, because at that point, their interest and rights are probably being reduced.
Yeah.
In any modified agreement.
Yeah.
And good luck getting that one person or two people who are considered the problem, to override their decision or their vetoes.
So, okay, so I realize you probably don't handle this type of thing as a regular thing, but if you were the one setting up the contract, how would you set it up to make sure it was fair for everyone involved, out of curiosity?
Oh, easy.
Okay.
That's a simple thing to take care of. You
Okay.
have to have different portions included in the written contract that say, if we need to kick somebody out, or for whatever reason, one of the members is leaving the band, you have to have specific language in there that says what's going to happen. Are they required to sell their interest back to the band? Are they allowed to retain that interest the entire rest of their life? Which kind of sounds like the Soundgarden situation to my ears anyways. So you want to have specific instructions that if somebody leaves the band for whatever reason, that their interest is going to be valued at market value, and then it's going to be sold back to the band, which means the other members would then take over their interest. And that's what happens. And so you have to have that agreement at first. And then second, in the case of if somebody passes away, you should have a provision in there that says that the surviving spouse or the heirs do not have a vote or any decision-making authority in the band, and it's left to the remaining surviving members.
But would that not be unfair for the surviving heir?
Doesn't matter.
Doesn't
At
it?
that point, they only have a potential interest in the future.
Fair.
They
Fair.
don't have any right to object to it at any point.
So, Corey, did you have a follow-up before I ask the next question?
No, go for it.
Okay. I don't know how recent this was, but the last thing I remember seeing was, and I could be out of the loop on the Soundgarden case here, that the band tried to buy Vicky out. I think it was like for $270,000. Can you I don't know how much you know about that, but can you kind of talk about that? Because that seems like a low offer, and I can understand her viewpoint, but I don't understand something.
When I first read that and I saw the amount that they had offered her to buy her interest in it, I was pretty shocked. You know, just from my knowledge of Soundgarden, I think that her interest would be worth more than $275,000. It doesn't mean that she won't continue to get songwriting royalties and performance royalties. She'll still get all that stuff that he's entitled to as the songwriter or performer, and she'll get paid through ASCAP or whoever pays out the royalties to Cornell's heirs. So that's completely different from her interest in the band. Because if she sells her interest in the band for $275,000, she no longer is going to get a percentage of any merchandise.
Yeah.
Any other things related to it, like let's say if they license a song for a commercial, she's going to be cut out of that if she did it. So I think just looking over the course of her lifetime, or the anticipated, like, for lack of a better term, shelf life of the band as a marketable entity, it's going to be worth more to her over time than $275,000. And I don't know how they came up with that number. They probably had some accountant or somebody try to put together a valuation. And in that instance, she can accept or reject or counter. And the fact that they're making that offer tells me that, one, there might be a provision in the band agreement that says that they're allowed to make an offer to buy the share. Or it could just be that their lawyers who they hired to help them in this situation have said, let's just make an offer. Let's see if we can get it settled without spending more money, because it's definitely going to cost each party more than $275,000 in attorney's fees. It's probably already well exceeded that amount with all the back and forth and different suits that have been filed in LA County Superior Court,
Yeah. So I don't know where I want to go with this, because there's a lot to unpack on this here. So why don't you just continue with your thoughts, Russ? Because I'm not sure where to take this, but I know there's a lot here.
Okay. If it's getting too in the weeds, just let me know. I'm trying to just do an overview of kind of some of the general issues that I see. So I really think that a lot of it comes down to, they made an agreement at the very beginning when the band started taking off, and they never changed it as they got more successful, because like I said, that'd be hard to probably change it after they got successful. And now they're stuck with it, and they're having to navigate the consequences of their own choices and decisions. And that's why it's important that things and issues and potential events like this, where one person passes away at a young age, you have to think about those type of issues when you are negotiating or coming up with an agreement before it's signed. And most people don't think about that, especially when it relates to the will contest or the estate context. And
Yep.
will the probate estate have a continuing decision-making, interest and authority in the band, even though the original members passed away? People
So-
don't think about estate planning because they don't want to think about death.
Well, Russ, let me ask you this then, because I mean, obviously, I would think, and that Soundgarden would have had a lot of lawyers, at least after they got successful,
Mhm.
or you think. Why do you think this wasn't taken care of earlier then? Because they would have had they must have a big legal team, I would think. They would have to.
I would think that they were coming up with this probably around the time when they were getting ready to release Louder Than Love, their first major label album.
Yeah.
That's usually when bands really come up with a big agreement, because if they've been on Sub Pop or SSD Records, like Soundgarden had been, releasing EPs and things like that,
Yep.
before they got onto the major label buildup and releases. Yeah, the chances are they didn't even think about it until around that point with Louder Than Love. And
Yep.
then it was a situation of, we're all best friends. We're in this together. We're a team. All for one, one for all. We're
Mhm.
going to treat everybody equally. Everybody's going to have the same right, to make a decision, and everybody has to agree or nothing gets done. And a lot of partnership agreements and just business agreements in general are written that way. And it can lead to inertia
Yeah.
where nothing gets done and nothing's able to be done.
So how do you overcome that? Do you have a legal opinion on that?
Not really, no.
Just
You have to look at the written words, in the written document. And if there's no way to get out of that situation, you're basically just suing each other to try and get some judge to agree that there's a legal basis to allow something to happen. And
Yeah.
that's expensive.
Yeah. Corey, did you want to ask a question? I keep thinking you got a question.
I have a follow-up. So we keep talking about and bringing up band agreements
Mhm.
and, how difficult it is to change that. How often should a band maybe revisit their agreement just to make sure that everybody is on the same page? Because an agreement that was settled on, 6 years prior,
Mhm.
a lot can change in those 6 years. So would you recommend annually they just revisit everything to make sure that everybody's on the same page? And then on the flip side,
Mhm.
as members change,
Ooh.
how could those band agreements be revisited?
Great questions. And the first one is, anytime there's a major change with the band, whether a member leaves, a new member's coming in, or you're signing a new record contract or marketing agreement with somebody, major big changes are a good time to reevaluate and review what had originally been agreed to. So, and that's in general as like an estate planning type of advice I give to my clients is, anytime there's a major life change, go take your estate planning documents into the lawyer, have them look at it, because there might be some big changes that need to be made. So those kind of relate together in the band agreement and the estate planning sides. But also when it comes to, I'm glad you mentioned, Corey, about the band members leaving and what happens, because that happens, quite regularly. And that's why you have situations where a band's out touring, like Testament, and you got the members who've gone in and out, like Alex Skolnick and the bass player, who they don't have any ownership interest or decision-making authority or anything in the band anymore, because they left, the remaining members bought out their interest. So that's why it's Chuck Billy and and the guitar player, the other guitar player, the guys who've been in it the entire time, they own Testament. Everybody else is a for hire contract employee of the band. They're not even employees, they're basically independent contractors. You know, they sign up and they get paid a set rate for doing a tour or recording an album, but they don't have any authority to say anything about how the band's run. And if they don't like it, they can leave. They can find somebody else to play bass. And that's what they've done, unfortunately, to the original bass player. And I can see how, from his perspective, you know, it's a pretty raw topic. But it sounds, from everything I've read on that type of case, that was in the agreement, and he accepted the payout and he sold his interest. So a lot of it comes down, I guess, to answer even further a previous question. You don't want to be in the position of having buyer's remorse or seller's remorse. And these are important things that need to be considered before you sign anything in writing, before you sign any agreement. Because, like I said, it's going to be hard to undo it later on. And so did I answer your questions, Corey?
You did. And then I have another one. You mentioned any major changes with the band agreement should be looked at. What about major changes in the personal lives of the other members? So say one of the members gets married or has a kid or something like that. Are there any instances where the band agreement should be revisited in those kind of instances when it's like, okay, well, if I pass away, my wife or my kid gets XYZ? Is that another good time for people to revisit these things?
Not especially, because any of the estate planning side of things, where what will happen, the interest will go to the spouse, what the spouse can do. That's on the estate planning side of things. That's not going to have any sort of reason or ground to redo or modify the original agreement, because they're just separate. And it's going to be assumed that the band member's interest is going to be passed down according to state law if he passes away. But you want to have a provision in the band agreement saying that in that instance, the band has a right to purchase the interest from the heir. And that if they can't agree on a price, then they can go to court and get a court order saying that the value of the interest is this, and the band surviving members have to pay the spouse a set amount based on the judge's decision or the court's decision.
I want to interject, guys. We've got about 5 minutes left, just so you guys know. What else do we need to cover in 5 minutes on this, Russ?
Be aware of what you're negotiating.
Fair.
Be aware of what you're signing. And if you have any problems with what has been presented to you, don't sign it. Take it to an attorney who's knowledgeable in band agreements and things like that, and have them look at it, because you have a right to independent legal advice before you sign anything. And if you're getting pressured in any aspect of life to do something that you're not comfortable with, that's a red flag. And you need to be aware of it, because you're not going to be able to undo it except for the most extreme circumstances, because the law presumes that you've read what you signed, you understand what you signed, and you actually agree to follow the terms of what you signed.
So now, what if there isn't a written agreement? Hopefully we got time in 4 minutes to cover.
Look to state law. It's going to be considered a partnership. And you just have to look at state law. Different states have different rules of, you know, what happens in partnerships if there's not an agreement. What happens to a party's interest if someone dies. What happens if one leaves. And in that instance, you just have to look to the general partnership laws for the state where the band is set up or operate.
Fair. Cool. Corey, what other follow-ups we got in the next 3 minutes?
I am good on my end. This is a lot for people to digest and absorb.
Cool. Russ, do you have any final words you want to go over on this?
Just know what you're signing.
Cool. Awesome. I think that's probably the best advice you can give. And before we end,
I had one more question.
Okay.
So I know that in certain legal situations, prenups is a good example of this. It is advised that people have their own attorney look at the contract, look at the document. Would you recommend that each member of the band, like the band have an attorney, and then each member of the band have their own attorney look at the band agreement to make sure that it's, you know, balanced and fair, or is that overkill?
No, you definitely should, because the attorney for the band doesn't represent the individual members. They only represent the band, the entity of the band. So they're not going to have any duty to, you know, if one member leaves, they're not going to have any duty to be that person's attorney. And that relates back to your question, which is you always need to protect your own interests. You always have to have your own legal advisor look at something before you sign it, because you're not going to be treated specially by the band attorney.
Mhm.
Does that make any sense, or am I just like speaking in
No, it
circles?
definitely does. That's exactly what I was asking.
Okay, well, I'm glad then.
The answer is yes. Get your own attorney and have them look at it as well.
Correct.
cool. So to end off, I want Corey to do her final question. The final.
The final question.
The final.
What is your favorite dinosaur?
Pterodactyl.
You know, that is the second podcast in a row somebody has said pterodactyl. I've asked that question a lot, never gotten pterodactyl, and now 2 in a row.
It must be a trend. I'll check Twitter.
Cool. Okay, and with that, party on, Corey.
Party on, guys.
See ya.